Yep, that's us now live.
Okay, great. Thank you very much. So good morning, everyone. My name is David Liddell, and I'm a reporter with the Directorate for Planning and Environmental Appeals. Can I just, for those of you who I can see on screen just now, can you just put your hand up just so as I know that you can hear me okay? Okay, great, thank you. So just before we start, for anyone who's observing today only, can I ask them to have their cameras and microphones off, just so that I have the participants in front of me. And for others who are participating, if you can all put your mics on mute for the moment, please, just so as we can all everyone can hear me on best quality, and if we can all try and mute our microphones when we're not speaking, please. Okay, I'll ask everyone who's participating in this morning's meeting to introduce themselves shortly, but I just have a few formalities to go through. First of all, so we're here today to discuss the procedural arrangements for the exchange of further written evidence and for the one or more hearing or inquiry sessions that I plan to hold for to consider an application under to consider the proposed development at R3 Kerrs Dairy Farm, Bridge of Allen. Now, I've been appointed by Scottish ministers to report to them with recommendations on whether or not the appellant's proposed development should be given planning permission. And the description of that development is a public park, residential development, including housing of 600 units, commercial space, neighbourhood centre, improvements to road and drainage infrastructure, and a new primary school. And today's meeting, just to let you know, you should be aware that this is being recorded. It will be available to view on our website thereafter. It will be retained and used for purposes including document retention, training, and providing information to members of the public. So by participating, you're consenting to the use of this information for those purposes. Obviously, already Mr. Thompson might be having a problem with connecting. So hopefully, otherwise we'll be fine from an IT point of view. But if anyone's having any issues hearing or participating, then just let me know or let Callum know somehow, and we'll pause and try and sort those out. So that's fine. So before we go any further, I'm just going to ask those who are participating to introduce themselves to everyone. And so I'll start with the applicant, and I can see Mr. Findlay there.
Yes, good morning, sir. My name is James Findlay, Queen's Counsel. Today I with me Anthony Aitken, who's still struggling to get in, but he's in the same room. Fraser Mitchell, Richard Phillips, Geraint Hughes.
Okay, thank you, Mr. Findlay. And on behalf of the council, Mr. McMurray.
Good morning, sir. Yes, I'm Mark McMurray, partner at CMS, appearing for the council, and I'm joined today by Charlie Haggerty, legal manager, and Mark Laird, the development planning team leader.
Thank you very much, Mr. McMurray. And on behalf of, I think, both Bridge of Allen and Causeway Head Community Councils, Mr. McDougall.
That's correct. I'm a member of both community councils and represent both community councils at these meetings.
Okay, thank you very much. And I think just appearing on his own behalf, or here on his own behalf, Dr. Anderson.
Yeah, hi everyone. I'm just here representing the university, sort of informally. The university, we have quite a lot of turnover in terms of estates and campus services people at the moment, as well as our environment officers just retired. So I had given some comments previously about connectivity to the university and just trying to update on that.
Okay, that's fine. Thank you. I can't see your video's not turned on, which is fine if that's the way you prefer it. But I'm just to let you know, if you wanted to turn your video on, that's fine. You're a participant, but it's entirely up to you. Okay, and so the last person who was intending to join us was, of course, Mr. Thompson, but he's not here at the moment. Oh no, I'm sorry. Also, Mr. Neves on behalf of the development, the university as well.
Good morning, everybody. Yes, Philip Neves with Palomino Planning. I'm representing the university's estates department.
Thank you, Mr. Neves. Sorry, I almost forgot there. Okay, I will turn back to the agenda then. The second item is just the purpose of the meeting, and it's not going to take as long, I don't think. I said at the start that the purpose of today's meeting is just to discuss the procedural arrangements for the exchange of further written evidence and for the oral sessions that I plan to hold, or one or more that I plan to hold, and so we won't be discussing the merits of the proposed development today. Is everyone content with that, or are there any other kind of procedural questions or issues that anyone needs to raise before we just move on to the other items in the agenda? Okay, that's great, thank you. So if we move on then to item 3 in my agenda, and I assume everyone's got that, you can raise your hand if you don't have access to that. So this was the further procedures for matters related to housing land supply, which I think is probably sensible to deal with those first. And the first bullet point was, is there a need for updated evidence and position statements? Now, so obviously I have extensive evidence on housing land supply already, in particular from the appellants. I'm conscious though that since most of that, the 2020 housing land audit, I think, has now been finalised. I had a draft version or information on the draft version before me already. There's also been the court judgment, of course, following the judicial review of SPP 2020 and the associated planning advice note. I imagine that the consultation draft of MPF4 might not be long in coming, although I'm not aware of what plans there may be for that. So it's in that context, I wonder whether there were any views on this point as to whether or not, what need there was for updated evidence and position statements. So, Mr. Findlay, first of all, from your client's point of view, have you got any thoughts on this?
Yes, I'll take it briefly to begin with, but in our view, there is need, because the statements you have are, the evidence you have is from much earlier in the year, and the 2020 housing land audit, finalised earlier this year, presents a snapshot from, I think it's June of last year. We also understand that the draft 2021 housing land audit, so I think it's going to be the draft, is due to be published or made available on Friday, although Mr. McMurray may be able to assist more with that. We're obviously anxious to have a result one way or the other as soon as possible, given the lengthy history of this matter, but we do consider there is a need for updated evidence and position statements in respect of housing land supply. There have also been a number of decisions by the council that we consider that you would need to take into account.
Okay, thank you. I mean, that's not unexpected. That would be your position. Mr. McMurray, for the council, do you have a view on this for your clients?
So I think we're all in agreement on this so far. Yeah, I think we would agree for the reasons you said, that there probably is a need for updated position statements, just given the changes and the anticipated National Planning Framework 4. On the 2021 housing land audit that Mr. Findlay just mentioned. I believe that a draft will be shared with Homes for Scotland in the coming weeks, and it's anticipated that by the end of January it will be in finalised form, which again is probably, I would anticipate, probably have an impact for the timetable we'll be discussing this morning.
Okay, thanks very much. Right, yeah, so we will come on to talk about timetables, so that's useful. So can I just ask, obviously I had anticipated that both the appellants and the council would take part in an inquiry or hearing session on housing land supply. So leaving aside flooding and transport matters for now, does anyone else planned? Would anyone else intend to take part in the inquiry on housing land, or would the other parties just be leaving this to the council and the appellants? Mr. McDougall, I don't know what the community council's position is.
I think the housing land supply is something entirely between the council and the applicant. I don't think anyone like myself out with the actual dealings with these figures can add anything to the discussion.
Okay, that's fine. I've noted that. Unless anyone else tells me that they want to take part, then and just put your hand up if you want to say something. Then I'll assume that's the case. When I send out the note of this meeting, I will set out who said they want to take part and what procedures, and everyone get a chance to confirm that I've got that right anyway. So, but that's fine. That's kind of as I had maybe anticipated. Okay, so that's fine. The second bullet point I had then under that agenda item was whether or not we should have a hearing or an inquiry session. I was going to explain the difference between those two types of process, but both for the council and the appellants, you'll be well aware of that, so I don't need to do it, I don't think. Mr. Findlay, your clients had, I think I'm right in saying, certainly initially, that they were pressing for an inquiry session on these matters. So I just wondered what the current view is.
Yes, we're still firmly of that position. The last consideration of housing land supply clearly demonstrated, in our view, that the differences between the parties, and that firstly some form of oral hearing is necessary. In our view, there are distinct differences between the parties that are best explored and explained for you by way of an inquiry session. The two main reasons for that: firstly, a hearing session would require you to get to grips with both sides' evidence on housing land supply and to know which questions to ask. And whilst I'm not suggesting that's not a matter that you would be capable of doing, what I am suggesting is that the knowledge to know what the issues are will be hard acquired. In our submission, you are likely to be better informed by an inquiry session with questions being asked by whether it's Mr. McMurray or someone else for the council and myself. It is likely that the parts of the housing land supply issue will not be, or position will not be an issue, but there will be a number of issues relating primarily to some sites and to the way in which methodologies are applied, which in our submission you would benefit from having an inquiry session on. Our view is that an inquiry session is not likely to take more than 2 days, and may well be less than, considerably less than that, depending on the areas of agreement, which is difficult to forecast at the moment, but given that the housing land supply position and draft will be coming out soon. But for those reasons, so we would request an inquiry session.
Okay, thank you. And Mr. McMurray, excuse me, what's the council's? Sorry, I should say I do have a bit of a cold, so if you hear the odd sneeze or sniffle, then apologies for it. Mr. McMurray.
Thank you, sir. And I think to summarise the council's position, I think its preference would be for a hearing session in the circumstances. There are a few reasons for that. Firstly, I actually think, subject to what Mr. Findlay has to say, I think it would be possible for the parties to agree the various different calculations that would apply with the different methodologies. Where there might be a difference on which is the preferred methodology, I think the parties would be able to agree the calculations, or at least the vast majority of it. Secondly, I think there aren't really essential facts here in dispute, and the areas of difference are actually relatively narrow and relate principally, as far as I can see it, to the sites which should be included in the effective supply, and also the preferred methodology. And obviously, I'm not trying to anticipate what might come out of NPF or anything like that, but that position may change with developments in the coming weeks. And given the relatively narrow areas of dispute, as I see it, I think the council, we were of the view that this might best be explored through a discussion in a hearing session. And so just one final point, so I think I probably should clarify, when I mentioned the draft housing land audit, what I should have said was it's the draft programming that feeds into the housing land audit that will be shared in the coming weeks with Homes for Scotland.
Okay, thank you. And you also said that would be finalised at the end of January. It's anticipated that would be finalised at the end of January. Would that be the audit itself, or just the programming that feeds into it? Sorry if I'm putting you on the spot with that question.
No, I believe it is the finalised audit itself, which will be published in January, by the end of January, sir.
So could I
respond briefly?
Could I possibly respond briefly to that?
Certainly, Mr. Findlay, but just before you do, I think Callum informs me that Mr. Thompson has maybe been able to join. Mr. Thompson, are you with us in the meeting now?
Yes, thanks very much. Apologies, I couldn't get the link to work.
No, it's quite all right. I'll just quickly recap you then, and I've just so apologies if that wasn't working for you. So we've done the introductions. Hopefully you can see people's names up when you hover over the thumbnails. We have. I was explaining that our purpose today is just to discuss the procedural arrangements, and we have moved on to talk about the inquiry session, well, hearing or inquiry session on housing land, and we've just been talking about the procedures for that, whether it should be hearing or inquiry. But more importantly, perhaps for you, at this point, it's just the council and the appellants who would intend to take part in the inquiry on, as far as housing land is concerned. And Mr. McDougall for the Community Council said that they didn't want to get involved in that discussion. So I just wanted to ask you, Mr. Thompson, is your interest elsewhere? It seemed to be mostly in relation to flood risk that your representations are, but I just wanted to check, would you be anticipating taking part in a hearing or inquiry in terms of housing land supply issues?
David, thanks for that information. I'm actually an elected councillor on Stirling Council, so I'm conflicted. So I wouldn't take part in anything that's related to Stirling Council.
Right, okay, sorry.
So drainage and roads.
Right. Okay. My apologies. I hadn't realised that you were an elected member, Mr. Thompson. So that's fine. Okay. So that simplifies the discussion for this part of the agenda, and so I'll just continue with the council and the appellants on housing land, and then we'll come back to the other items in the agenda. Thank you very much. I'm sorry, Mr. Findlay, I cut you off there.
No, sir. That's absolutely appropriate to recognise Mr. Thompson. A successful struggle at joining, a struggle that he was not alone with this morning. So just in terms of the MPF, whilst a draft will be coming out, my understanding is that it's not due to be finalised till September next year, and there will need to be, if I can say so, adequate consultation, so that in our submission, there's no justification for tying any form of procedure or indeed date to the publication of that document, although obviously it will be a matter of interest to all parties. Secondly, I understand Mr. McMurray's point. My understanding about what is ready for the housing land audit, my understanding is that the completion figure may not be yet available. That may be the most significant figure lacking. But again, in our submission, given the extensive delays in this matter, that there is no justification for waiting to January, which is an uncertain date in any event, for the full procedures are set to deal with this issue. And thirdly, whilst I agree with Mr. McMurray that I'm sure parties are quite capable of agreeing the mathematical calculations depending on the various methodologies, and that it is as to the sites and that are in dispute that in our submission cross-examination is required on. The council has a lengthy history of undersupply, a point that the appellant has made on occasion, and the same sites feature in their purported supply year in, year out, with no progress being made. And that is a matter that the reasonableness or otherwise of including sites within housing land audits or housing land supply is a matter that in our submission is best dealt with by cross-examination. Thank you.
Okay, Mr. McMurray, have you anything further to say at this point?
No, just briefly, sir, but trying to avoid straying into the parties' respective positions on the substance of the appeal. I think we already have probably quite a lot of information in the statements already on those sites, which will probably give you a good flavour of the history of those sites and the parties' respective positions and submissions that have already gone to date. And for that reason, I think a hearing could quite easily be conducive to discuss that matter.
I think you may be muted.
Beg your pardon. Yeah, I want to go away and think about this. As I understand, most of what you said is not been surprising. From the appellant's point of view, it seems to me one of the key things they want to drill into is as Mr. Findlay said, the prospects of progress on a number of sites which might or might not be in the new audit. And so I suppose I would say two things about that. I'm not wildly enthusiastic about long cross-examination of progress on sites that are nothing directly to do with the development in front of me, and which, without jumping the gun, there's a high degree of uncertainty and supposition, if you like, in all of this kind of material. having said that, if that's what's of interest to the appellants, and with that kind of caveat, that does feel like more like a cross-examination, a subject for cross-examination rather than a subject for me to probe into. So I think at present, and particularly since it's the appellant who was asking for this oral session, the appellants who are asking for this session, I'm more leaning towards an inquiry session than a hearing session. I'm comforted by Mr. Findlay's estimate of a couple of days for that, which might suggest my fears about overlong cross-examination on different sites might be unfounded. So, but I will go away and think about that, and put it put out the procedure that I decided in the note of the meeting. Is that sufficient on that particular item before we then move on to the timetable for the exchange of evidence?
So there was just one sort of final point just on that. I'm conscious that originally this was an application which was recommended for approval by council officers and then refused by the council itself. And I'm just conscious that obviously with if matters are going to be discussed on housing land supply, that's something that the council officers can address at an inquiry session, but I'd be quite keen to ensure that the scope of the inquiry session is restricted to the issue around housing land supply and whether or not there is a shortfall in the effective housing land supply, so we don't stray into matters which the council officers may feel uncomfortable addressing, given that history of the determination. And I just wanted to put that note down there just to make sure that the session was carefully scoped.
Perhaps I can add that I quite understand the point Mr. McMurray is making. I quite understand the continuing position of council officers and the distinction between their position and the council, and that it seems to me perfectly appropriate for a council officer to give evidence on housing land supply, and in any cross-examination, I would restrict myself to housing land supply issues and not stray into policy or wider issues on that. So I understand why he's raised the point, but hopefully it should not be a matter that gives rise to concern.
Grateful, Mr. Findlay.
Okay, thank you. Yes, I had assumed it was. Yeah, I take the point about. I mean, it's some time ago now, some time now since that original recommendation was made. But I take the point that my thoughts would be that it would be about housing land supply. But if you start to have concerns about creep, then you can let me know about that. Okay. Okay. So if we talk then about a possible timetable, Mr. Findlay, you said you were keen to your clients were keen to push on. I mean, so am I. I've had this case for quite a while now, and I want to make progress with it. And so I want to look ahead as we have obviously the exchange of information. You've confirmed that you would want a chance or the opportunity to put in an updated position statement. So I was just looking ahead at my diary and thinking about when we might be able to have an inquiry session or a hearing session. So if I set out my kind of cautious thoughts on this, and then you can react to that rather than leaving it open. But if I was to send out a note of this meeting at latest by the end of next week, that would, so the 5th of November, typically we give 14 days for parties to confirm that they want to participate. I set out in the note, so that would take us to the 19th. Excuse me. if a further 2 weeks after that would be the 3rd of December, Friday the 3rd of December, and so I'd wondered whether it's inquiry statements or hearing statements, that would be a possible date for the exchange of those. There will presumably, I obviously have a lot of documents in front of me already through the appeal, but there might, well, it sounds like there will be other documents that people will want to put in front of me. So I wondered whether an exchange of documents could take place by the 17th of December. We then, of course, start to get into the Christmas period. So I wondered whether, with that in mind, and also with the fact that we'll come on to in-person versus virtual inquiry soon, but the week of the 10th of January, we certainly couldn't have an in-person inquiry just because DPA is another in-person inquiry running that week. So I was thinking the week ending the 7th of January for preconditions, and perhaps therefore then the week beginning the 24th of January for a hearing and inquiry. Now, that was just my thoughts on what's doable, and maybe we could do it a bit quicker, or maybe that's too challenging, but that was my kind of first musings on the subject. So I wondered what those two parties taking part think about that. So Mr. Findlay, first of all, have you discussed this with your clients at all?
Yes. So in general terms, that is a fairly swift timetable with some room for debate. Can I work backwards in the sense that I'm involved in the other in-person inquiry on the 10th of January, so I'm also unavailable then. But I'm actually in court on the week beginning the 24th, so the week beginning the 17th would be our preference, and to set the timetable accordingly. Just to reassure you, our view is that there are likely to be 4 sites that may need to be considered in cross-examination. But I maybe that you've heard me cross-examine before, which gives rise to your concerns about length of cross-examination. But my view is that it is with the background material in, and with some goodwill between the parties and agreeing matters and a statement of agreed matters, 2 days is the maximum we need in that week, with potentially submissions to follow thereafter. So in general terms, the timetable you set out seems to us to be appropriate. The only point I was going to make is that when inquiry or hearing statements will come out on the 3rd of December, it may be that there could be an exchange of documents almost as early as that date, because as I understand it, both parties are going to be, are mature in their understanding of their position. There are unlikely to be many new documents out, and the earlier the parties get that, the more focused their evidence is likely to be. There could be a date for further exchange following that, if necessary, but that's the only. So the only 2 suggestions I make with respect to your proposed or possible proposed timetable, I'm not saying any further than that, are to bring the inquiry a week or the hearing a week earlier, and to perhaps have slightly early exchange of documents. But apart from that, leaving aside the detail of the dates, that seems to be a sensible inquiry timetable, using the word inquiry without prejudice to your decision as to whether it's going to be a hearing or inquiry.
Okay, thank you. And yes, I did say preconditions at one point, but I've also noted or hearing agendas. So yeah. Another consequence would be if we were doing the inquiry or hearing on the week beginning the 17th, then I'd still want enough time. I still want the preconditions in early enough to give people enough time. So we maybe would bring the preconditions forward to the start of that first full week in January rather than towards the end of it, if provided, because there's hopefully that would be enough time. Okay, so if you, I know that's I'm jumping those timetables on you, Mr. McMurray, but if you got any get any thoughts on that kind of process?
I don't think the timetable creates any practical issues as far as I can tell so far, although I would need to double check with potential witnesses, but in principle that seems okay. I think the only issue the council would raise is given that if we're going to have an inquiry on session or hearing in the week commencing 17th of January, with the housing land audit being published only maybe a week or so later, whether it might actually be more efficient and prudent to wait a few weeks so that we can actually take account of the up-to-date housing land audit position in any session. But clearly that's a matter for you, for yourself, sir.
Have you got any thoughts on that, Mr. Findlay?
In the sense that I understand that the programming is likely to be, council thoughts and programming are likely to be out by the end of this week. It's the completions figure, and whilst the completions figure may not be formed, as I understand it, the completions figure is likely to be known to the council by that stage. They can publish that and make that available, subject to appropriate caveats in advance of the formal publication of their housing land audit. There may be, with all completions figures, there may be fine detail that needs to be ironed out, but it's unlikely to form the subject matter of dispute between the parties before you. So in our view, it would be unnecessary to delay the inquiry for such fine detail to be ironed out. We do have availability difficulties in the whole of February due to other commitments in court and inquiry. So the week of the 17th would be by far the most appropriate week. And we are, I mean, I know you're concerned about slippage too, having been appointed for I think over a year now, but I think the application, first of all, the application went in over 7 years ago, so we are keen that you err on the side of an earlier date than a later date.
And just so as I understand correctly, I anticipate one of the main things you want to ask questions about is the future programming, anticipated future programming of the sites that are in the audit. And so will that information, will that programming be there and have been finalised by the 17th of January, or is that something? And I'll ask you first, Mr. Findlay, but you might have a view as well, Mr. McMurray. But do you think you'll have?
I understand it. I understand that certainly the council provisional views on programming are going to be made available this week, as I understand it. And before the end of January, we should have had Homes for Scotland's input on it. Obviously, we're not bound by Homes for Scotland's input, but you will obviously pay regard to it. So in our submission, the parties should know what their positions are going to be, or the inquiry should be capable of being informed of what parties' positions are going to be on programming by that week. If there's some outstanding detail as to completions, certainly that has not formed part of the dispute between the parties so far. In terms of, I think the only issue on completions that there's been as to whether, just thinking back to previous sessions, is whether there've been replacement of houses rather than new housing, but I don't think that's a completions issue, and that was a minor issue anyway. So that certainly those instructing me are keen to make progress on the 17th, if at all possible.
Okay, thanks. Yeah, sorry, Mr. McMurray, carry on.
Sorry, sir. I think the council's position is that yes, draft programming will be known at the stage when parties are preparing their inquiry statements, precognitions, things like that. But it is just that, it is a draft programming, and it's the council's starting point, which will then be subject to discussions and input from Homes for Scotland over a course of time. And the final position is probably unlikely to be known by the time parties are finalising those documents, and it may well be that not that I'm just going to say wasted inquiry time, but potential issues being discussed during inquiry which could be resolved by the final publication of the housing land audit only a matter of a week or two later.
Just, I think last year the housing land audit slipped until April until it was finalised. And I make the point that we are not bound by any agreement between the council and Homes for Scotland, because in our submission we're entitled to challenge the thinking of both if they reach a view on programming, and the council's view on programming is or any position on programming can be effectively challenged at a hearing before you in the week of the 17th of January.
Okay, thank you. Well, again, I need to reflect. My instinct is to push on, because what might happen after the week that week of the inquiry is subject to uncertainty anyway. But I'll have a think about that. So can I just ask, witnesses, do we have an idea whether it's an inquiry or a hearing, in terms of numbers of witnesses, or even who they would be? Mr. Findlay, first of all.
So I think we'll only have one witness, who will be Mr. Phillips.
Okay, thanks. And Mr. McMurray, does the council give a view on that just now?
I anticipate at this stage it will be Mr. Laird. At this stage, we obviously will finalise in due course.
Yeah, I mean, that's fine. Just so as I've got a broad idea of what we're talking about at this point. We've already discussed days. We'll be talking about a couple of days, whatever week we choose. Usually we would do, if there's a need for closing submissions, we typically do these in writing afterwards, which I suggest that would probably be appropriate. That's fine in terms of the kind of nitty-gritty for exchange, how to exchange information. I probably don't need to get into the detail of that. You'll be well conversant with that. For our purposes, electronic versions of documents is fine, and you can agree between yourselves the arrangements for exchange. We'll put everything that we receive on the website so as that any other interested parties can have a look at what's there. Okay, I think on housing land, that's probably the discussion. I've asked everything I wanted to ask on that, but is there anything, Mr. Findlay, carry on?
So I think it's just whether it's a virtual or a in-person hearing, and I know there was some particular discussion meeting for. Our preference would be. Our preference. Sorry.
No, my apologies. I lost you for a moment there, Mr. Findlay. Could you just start again, please? Thanks.
Our preference would be for an in-person inquiry, but it's a matter for you. In the I understand the inquiry the week before is currently programmed to be an in-person inquiry, and for the same reasons, without seeking to take up everyone's time, our preference would be for an in-person inquiry if possible. Matter for you and Mr. McMurray.
Can I ask? Yes. Which one is that? Can you remind me?
It's Kirken Wind Farm. Certainly, I acknowledge that there's a difference between cross-examining on housing land supply figures, which is much more documentary, which is perhaps less difficult virtually than cross-examining on landscape and visual matters, which is more difficult to do virtually. But that said, our preference would still be for a virtual inquiry, because that in our submission, sorry, in-person inquiry, my apologies, I'm grateful, that is more efficient, effective, and it is fairer. Not that I'm suggesting virtual inquiries are unfair.
Okay, thank you. Mr. McMurray, does the council have a view on that?
The council's preference, sir, would be for a virtual inquiry session or hearing session, depending on the final decision on format. The principal reason for that is that the council is very much, apart from obviously frontline services, still working and operating remotely on most things, and I think pretty much the only meetings the council are having presently, which are in person, are essentially LRB site visits, which are external and outside. So for that reason, the council's preference would be for virtual sessions. I must just add that we have been involved in virtual inquiries over the last few weeks and found that they've worked quite well, particularly on an issue like housing land supply, where I think, as Mr. Finlay has acknowledged, it's probably easier than certain other topics that might otherwise be considered.
Okay. So yeah, I mean, as you'll be aware, almost all of our hearings and inquiries during the pandemic have been by video conference, and that's been the default position, if you like, and that's generally speaking worked well. I mean, there are different views about it, and there are pros and cons certainly, and it probably depends on the subject matter and how many people are involved. You may or may not have seen our current guidance note on that, and I'll send a link to that out with the note of the meeting, just so as people are aware of the current, most up-to-date position, and it's likely to be an evolving picture anyway. Our current position is that we are intending to return gradually to in-person hearings and inquiries where those are necessary and appropriate, and I suppose those are the key questions for me. Even if we were to have an in-person inquiry, that means social distancing, face covering, more health and safety procedures than people would have been accustomed to before the pandemic. It sounds. I hear what you've said there about subject matter and whether that may lend itself better to virtual proceedings than other possible subject matters. Since there are only two parties and two witnesses, two people cross-examining two witnesses, maybe a need for other people for as part of those teams, but still it sounds like we're talking about a pretty compact inquiry in terms of numbers of people in a room at any one time, which if we were to do it in person, would help. So that's fine. Again, I think that's something that I need to think about and probably also consult internally, because we need to make sure that we in DPE are being consistent in how we reach our views on these things. If we were to do it in person, I wonder whether anyone has thoughts about whether there are suitable venues locally. It would need to be a big enough and a big enough venue and I suppose a well run enough, if we can say it that way, that could accommodate a room sufficiently large for us, maybe breakout rooms for teams to go away and consult with each other during the day. So I don't know whether yourself, Mr. McMurray, or Mr. McDougall from the Community Council, is there any thoughts about, or even yourself, Mr. Finlay, any possible venues that you might suggest for an inquiry?
So that's something I can take instructions on, but I would imagine our team is likely to be maximum of 5 people, may well be less, and I'd imagine the council's is the same. So given the limited interest that there's likely to be in housing land supply debates to any sane member of the public, hopefully one wouldn't need a particularly large venue, but that's something we can seek to assist on in the next week. So suggest venues, but the council may well, or indeed Mr. McDougall may well have better information than we do.
Mr. McDougall.
There are several venues in the area. In fact, the Park of Keir inquiry was held in Dunblane. While I think the housing land supply numbers might be quite low, I think when we go into general terms, you may be speaking of more than 10 people, you may be nearer 15, 20, and I think that has to be taken into consideration as well. I would add, though, that I think when it comes to the other aspects, that I personally would prefer oral face-to-face meetings when it comes to cross-examination, and there would undoubtedly be cross-examination. It's very difficult to do in a situation that we have at the moment, rather than face-to-face. I think there are venues, even if we have to move into Stirling itself.
So in terms of, just in terms of venues, I would need to take instructions on that with the council and explore what options there are. One thing I would say is that it's unlikely to be a council building itself, because they are generally still closed for public meetings, and as far as I can tell, there's no prospect of that changing in the immediate future, and probably at this stage it would be difficult to make preparations and plans for a virtual, an in-person session within a council building. So we'd need to explore alternatives. And just on Mr. McDougall's point, I understand what he's saying there around, cross-examination and the benefits of doing that in person. Again, I just for your benefit, sir, reiterate just in terms of the topic, I think this is probably not one where we're, subject to Mr. Finlay's comments, one where we're going to need to be testing credibility of witnesses to the same extent as we might do on other topics, and that's why, again, I think the council thinks this, if we are going to have an inquiry, then a virtual one would suffice. But again, that's a matter for you, sir.
Okay, thanks very much. I had intended to discuss oral versus virtual right at the end, because of course that discussion might well apply if we are going to have hearings or inquiry sessions on the other matters that Mr. McDougall mentioned. So it was useful to hear your views on that, Mr. McDougall. Okay, I think that's probably deals with that issue then. And if you're content, if everyone's happy, what I want to do is return to item 4 on the agenda, which is about the progress on the updated flood risk and transport assessments. And so I was just interested, if everyone's happy to move on to that. Mr. Findlay, are you able to give an update on where we are with those bits of work?
Yes, so both of them should be available and arrive with you and other parties on Monday next week. And I understand we're still under the 2011 regulations, and it would be for the publication would be down to EPA to do, and the 21-day consultation period. So that's the it's not guaranteed, but it's a fairly firm timetable that they will be available a week on Monday. Both. Sorry, this Monday coming. My apologies. Next week, next Monday.
Okay, that's helpful. So just for other people's benefit. So yeah, so they would be there'd be neighbour notification. As I understand it, I think there'd be neighbour notification. There would be consultation with the statutory bodies, and there is publicity, which is a press advert or a couple of press adverts. So let's say that material's with us next week. It would take our office would then, I guess, arrange the publicity. It tends to take a couple of weeks to get all that organised. I think I had it as 4 weeks publicity, but maybe it's 3 under the 2011 regulations. I'm not sure which is the
case. No, I
think
you're right. It is 28 days.
So then, so there would be another 4 weeks for any interested party to comment on that new additional information. As is customary, we would then give the appellants the opportunity and maybe the council to respond to what's come in. And then I'd need some time to digest all of that. So, so we're talking about at least a further 10 weeks before I would be in a position to have seen all that information and decided whether or not I think I need either a hearing or inquiry session on either transport and or flooding. I may decide that I do, and I may decide that I don't. I just don't know at this point. So it just it's been helpful to get that timetable, but I wonder it's probably difficult to go further in terms of any discussions about what were we to do if we were going to have a hearing or inquiry on those matters, because I guess the answers to those questions might depend on what that information looks like, what people's comments have been on it, the scope of what I still want to know about. So I just wondered whether we proceed with the formal consultation under the IA regulations of that material, and that we park for the time being any further kind of detailed discussion about how we would, if we were to be hearing an inquiry session, when it would be, how we would run it, and so forth, because it just seems like there's 2 or 3 levels of uncertainty there about that maybe mean that it's not greatly worthwhile having much of a discussion about those arrangements just now. But that's my thoughts, but I want to hear yours. So Mr. Findlay, first of all.
So we agree, and I was going to suggest that you might want to, I think 10 weeks takes you to about the end of the year. If we are going to meet on the week of the 17th of January, we could program a further pre-examination meeting to deal with those matters then, if that would have given you sufficient time to reach a view. To deal with, if there is to be further procedure, it can be arranged. If there isn't to be further procedure, there's no need, but we can at least program that meeting for that date. I understand that a lot of those attending today have strong views on the subject, and and they'll no doubt be able to put those forward in response to the as part of the consultation responses once they've seen the documents. But I agree with you, sir. There's no point either side debating this at length at this stage, given the uncertainties that are available, that are evident. And so our submission would be to allow you to form your view, and then to, if necessary, have a further pre-inquiry meeting on that week of the 17th of January. And further procedure could be considered then, with the idea of, if there is to be a hearing or inquiry session, it could be reasonably swift.
Okay, thank you. Mr. McMurray, would the council have a view at this point?
I think just obviously in general terms, sir, the council's preference would have been not to have had sort of a slightly disjointed procedure in terms of having potentially one session in January and a significant delay before further sessions afterwards. But if you're minded to press on with housing and land supply, that's sort of, I think, is the issue. So it makes sense. What Mr. Findlay suggested, that it's probably too early to make a call on what the procedures may be and might look like, and if we are getting together in January, then that may well be a useful point to agree procedures and discuss that at that stage.
Okay, thanks. Yeah, I did think about that. Likewise, I agree. It's not ideal that if we might end up having a set of an inquiry session or a hearing session on housing land, and then something else a couple of months later. But since that second part is uncertain, I felt it was best just to arrange what we do know we're going to do. We're going to have to do, and just press on with that, because otherwise it just prolongs the process even further. So I take that point. Mr. McDougall, as I say, it will be only after the end of that process or the end of when I have all that information and the new information and people's responses to it that I'll be able to reach a view on whether I need an inquiry or a hearing session. But I suppose as it's put to me now, we would park that and discuss it again at the same time as we have the inquiry on housing land. And although you're not going to be involved in that's fine. We could have a separate, effectively a kind of second part of this meeting when we pick up these transport and housing land issues following that information. But I should say, if I, that would only be if we were going to have an inquiry or a hearing session on one of those subjects. If at the end of the consultation process for the new information, if I decide that I don't need any hearing or inquiry session, then that'll probably be it. I'll probably not want to ask people to persuade me otherwise. We would only be having another discussion if I decided that we needed to have either a hearing or inquiry. So I'm sorry, this is a complicated process, but I just want to make sure that I know what your views are on all this at this stage.
Well, my views are that the decision is finally yours. I would say that I think the housing land supply situation is putting the cart before the horse. If the flood risk assessment can't be sorted out, and it can be proven that it's not feasible or viable to build on this site, and prior warning, there will be submissions regarding the applicant's forthcoming flood risk assessment, which may cause a further delay on your timetable.
Right. Okay. I mean that's good, because that's the whole purpose of this next stage is to get people's views, people's reactions and responses and comments on the additional information. And as I think I said, it'll be a 4-week, once the notice, because it goes in, the press notice goes out, then there's a 4-week timetable. So hopefully that will give people enough time to respond within that timetable. Okay, Mr. Thompson, hopefully you've been listening to that. Have you got any comments to add at this point? Not so much on the merits, of course, but just on the proposal, if you like, to park. That I would take a view on whether we need any further procedures on transport and housing, transport and flood risk, once I've seen all this additional information. And if I was going to need that, then we would have a further discussion about the arrangements on the week of the 17th of January. So just want to know your views at this point on that prospect.
Yeah, thanks, Mr. Ludham. I'll take you back to the start because I think it's important to put this into the context that a drainage impact assessment was carried out. It was reviewed by SEPA and supposedly Scottish Water, who on a freedom of information request I found out that Scottish Water hadn't seen it. So I think we've got to make sure that all parties that have an involvement need to see the documents and respond to it. But on the back of that, because there wasn't any mechanism before, I had to deal with SEPA and the process didn't work. It was just emails going backwards and forwards. And personally, I believe that if there is a need to challenge this, that it has to be done either through an inquiry or a hearing where we do get to challenge the designer on the aspects that we have concerns over. So I listen to what you say and I respect it's your point of view, but I hope you realise that we've got to this point, very frustrated. Mr. McDougall, I'm sure will add to that if he wants, but we've always had to deal with SEPA and found this two-way process hasn't worked.
Okay, that's noted. Yes, so SEPA declined to take part in today's session because this additional information isn't available yet. They will be one of the consultation bodies that are given the new additional information on flooding, and we'll have a chance to comment on that. But I've noted, I know what you're saying, similar to what you said before in terms of your thoughts on process and your discussions with SEPA. Okay, Mr. Neves, has the university got an interest in this discussion?
Drainage is the university's main interest, and it's all to do with making sure that the university's position is maintained and protected. From what we've seen so far, it's probably sufficient for us to review the papers and not need any kind of extra sessions. But as I say, we're more interested in drainage and flooding.
Okay, that's fine, thank you. And of course, yeah, you will have the chance to review that additional information, and so if there's anything that comes out of that, then you can let us know. Okay, so Dr. Anderson, I think your interest was more in transport, but that's fine. It's the same discussion really. Have you got any thoughts at this point?
Yeah, sure. I mean, my positioning coming into this, it's actually been a while since I've been involved in this kind of stuff. So my position coming into this was, in terms of my written submission, was to really update on the change in my own circumstances and the fact that the evidence that I previously submitted, I guess, probably isn't necessarily up to date in terms of what the university's planning is. So Philip may have more information on this than me, because it's been probably 2 or 3 years since I've been in any kind of transport meeting for the university. So I guess really, my position here is I don't have any new information to submit, and my previous information is probably somewhat out of date. And perhaps Philip is better to take the university's position forward than myself.
If I could take that over, thank you, Craig. I mean, we have very much had a monitoring role looking at this to make sure that the university's interests are covered and its operations are not compromised. So I think what we would do is review any papers that come in and respond within the timeframes that we are given. So I think that's probably as much as I can say at the moment.
Okay, thanks.
Right, okay, that's helpful. I think that's everyone. I don't think there's anyone else to left to bring in on this part of the discussion. So yeah, next step in terms then of the additional environmental information for the updated transport assessment, the flood risk assessment, they will come into DPE next week. It seems we will then arrange for their publication and so on, and I'll just need to take a view at the end of that process and where I think I stand. I recognise that there are strong views as on these subjects and on the need for need to test them through a hearing and inquiry. I'm in no doubt of people's views about that, and I will keep that in mind when I'm deciding what I think is necessary. So I'm grateful for people's contributions there. So I think that deals with item 4. We've already discussed item 5 in terms of in-person versus video conference. I don't think there's any particular need to go back into that in the context of what additional sessions we might have. If subject to say that those are going to be a number of months later if we do have them, and so I think the position may have changed in terms of COVID anyway. So I don't know. The next steps now would be for me to get the note of this meeting out and to confirm what we've discussed and agreed, and my final decisions, if you like, on process for the housing land session. But is there anything else before we finish? Is there anything else that we haven't covered that we should do? Just put your hand up if there is, please. Okay. Right, that's great. So as I said, I will aim at worst to get the note of this meeting out by the end of next week, hopefully before that. So all that remains is just for me to say thank you very much. Thank you for persevering, Mr. Thompson, and you got here in the end. And I'm sorry we started without you, but I was just uncertain as to the difficulties you were having. Yeah, thank you very much, everyone. And I'll close the meeting now.
Thank you, sir.